of the 2021 virtual Lumsden and McCormick Exempt Organizations Conference. I know many of you who have registered, so again, it's good to see you all virtually, and welcome to the conference. Most of you know me. I'm Maria Gambacorta, the Marketing Director here at Lumsden and McCormick. So this webinar is being recorded, and we will share links to that along with slide decks and other information in an email to go out by the end of this week. Chat and Q&A are both enabled. So if you have questions for any of the panelists, if you could please include them in the Q&A box. Any questions for any of the moderators or the hosts, if you could put that in the chat feature, we would appreciate that. So as you know, we are offering CPE for this session. It's 1 hour for each session. And there are 4 polling questions and a survey at the end. So you have to answer all 4 polling questions and then complete the survey for CPE credits. We will be emailing you the certificates within 30 days of this event. So you should have them most likely before the end of the year, but if not in early January. We are having a little technical issues with the size of Lisa's presentation. So we will get it on the website and get it to you guys as soon as possible. But of course, you can see it here. So I'm going to pass the baton on to Sarah Dayton. Many of you know her as well. She's an audit partner who specializes in governmental entities, including school districts, public authorities, municipalities, and she does work with several nonprofit organizations. So Sarah, I'm going to turn it over to you.
Thanks, Maria. Good morning, everyone, and welcome again to this year's annual Exempt conference, virtual for the 2nd year in a row. Hopefully next year we can go back to having it in person and worrying about the snow. So we're going to kick off the conference this year with a presentation on being a human resources hero, the pandemic's aftermath, presented by Lisa Coppola. Lisa has owned 3 Buffalo area law firms in her 30-year career. She and her team at the Coppola firm take their clients' challenges to heart, whether they're starting a new business, taking their existing operations in a new direction, or facing a claim. Her law firm is the trainer of choice about New York's sexual harassment prevention laws. The Coppola firm is a certified woman-owned business qualified in New York State. Maria is going to add Lisa's bio and more information on the Coppola firm, I believe, to the chat. So if you'd like, you can check that out. But with that, I'll turn it over to Lisa.
Thanks, Sarah. Good morning, everyone. And what I want to say right off the bat is talking about employment law, which is what we're going to be doing for the next 45 minutes or so, is, as those of you on the webinar know, fraught with peril. When I talked with you last December, we were talking about all the fast breaking laws, both at the federal level and at New York State level, for some folks even in New York City, because the city is very prolific in its employment ordinances as a result of COVID. When I started planning this presentation in the late summer, my thought was, right, we were in the pandemic's aftermath. I will slowly remove the egg from my face because, of course, we're still smack dab in it, thanks to Omicron and a whole bunch of other factors that seemingly are not letting us loosen the grip of COVID on us. So we're going to be talking about what's going on, both COVID related and otherwise, in New York State law. Primarily today, I am perfectly happy having you folks interrupt via the chat. And this is what we're going to be talking about. Sarah will watch the chat, I know, for me, and we're good friends, so she won't have any hesitation interrupting, and I welcome that. It's really great in the moment to pose your questions or concerns or disagreements with me. As much as we lawyers like to think we're infallible, the word is we're not. We're humans just like everyone else. We work really hard to try to stay current on these things, and Lord knows our state government has given us lots of reasons to be doggy paddling through employment law this past year. So without further ado, you see the roadmap we're going to be taking today. We're going to be talking about a bunch of things, right? Pun on hero, because we're all living the Hero Act right now in real time, and then a series of other laws and issues that I think are really important, whether you are a human resources professional, you're an executive in your organization, you're in a human resources function in a government entity, or in a nonprofit, or in a charter school. These are all issues about which you need to be aware, you need to be on top of them, and you need to have some good resources in your corner. So let's jump into the HERO Act. That's a New York State law. It was passed back in May, I think, by our previous governor, and it's a reaction, no doubt, to COVID. What it talks about is when there is an airborne disease and what businesses need to do, and businesses includes nonprofits, folks, businesses need to do in order to keep their people safe. So the trigger to the HERO Act, and it's a really dense statute, right? It goes on for pages and pages and pages and talks about this notion of airborne infection. We know, right? COVID's an airborne infection. There's lots of other ones, and probably ones that, in my non-science fiction mind, I can't even conjure up yet, but, let's look at 2040 or 2070, and there'll probably be a whole host of other sorts of things floating around the air. The trigger is when the New York State Department of Health, in conjunction with the governor, because that's an executive agency of New York State government, says, we have a problem, right? We have a problem, Houston. We have a problem, New York State. Trigger the HERO Act. And what does that mean to those of you on this webinar? And I'm going to accept or separate out government entities, but I'm going to include charter schools here. Government entities, you're not off the hook. There's a corollary we'll talk about in just a second. So keep tuned in, right? The reality is when the governor triggers the HERO Act, and that was done over Labor Day weekend, it was a lovely surprise for those of us grilling our hot dogs and hamburgers and, maybe sipping a couple of adult beverages to all of a sudden see our governor say, HERO Act is triggered. Businesses, you need to do this stuff right away. And so what's the reality? It's much like, remember last year, it was just last June and July, there was that whole New York State reopening protocol, as many of us were allowed to go back into our workplaces, our offices, or our retail establishments, or our, agencies. And we had to have this protocol in place, this standard operating procedure, I call it, for safety. Things like making sure people weren't ill when they came to work or weren't ill when they visited your premises. Some folks did temperature checks. Some folks had employees and others fill out questionnaires. There was wiping down of high touch areas. There was, what's the word we now know? Social distancing. That phrase required, it was limiting capacity in particular areas of your workplace. So that reopening guidance and what you had to abide by last summer as you came back to work is very, very similar. So I don't want anybody to be sort of intimidated or cowed by the HERO Act, other than the fact that, it was triggered during a holiday weekend. It is much of the same sorts of protections and precautions that we take. And all of it is designed, right? Whether we are fans of our government or not, all of it is designed to try to ensure the public health and safety. So the reality is, if you are a business in New York State of any kind, profit or nonprofit, you should have your HERO Act plan both written and distributed to all of your people and in place. You should be executing on it and implementing it right now, and should have been since the day after Labor Day. And what does that mean? Well, for every different kind of business setting, right? If you're an office, a plant, I know we probably don't have any manufacturers in this group, but we might. There are some standard or model plans, and you see on the slide, there's the URL. The Department of Labor, bless their hearts, gave us some templates to work off of that would pass muster if they came in and audited you. And so that plan ought to be in place and ought to be implemented right now at your office or agency setting. So if you need to catch up, right, and some folks do, there are some things to keep in mind, right? Number one, in this statute, this law, New York State defines employees extraordinarily broadly. We don't see this definition, frankly, anywhere else. It's not what your audit partner, your tax accountant would say is an employee of your business. It includes independent contractors. It includes part-time workers. They usually, if they're W-2s, be considered employees. But it's very, very broad. So employees is a broad concept in the HERO Act. It also allows your people to refuse to work without repercussions. And we know in this day and age with labor shortages and real challenges, getting folks to come to work and be engaged, right? This is yet another place where employees can, if they choose, can try to really pressure you. And essentially the rule is if they feel like you are not keeping them safe, they can refuse to come to work. And that's another reason why, right? We try to be proactive. Certainly Sarah's group tries to be proactive. We in our practice are always talking and counseling our clients about proactivity. So we want to have this procedure, it's called a plan, in place. And what do you need to do here? You need to have it embodied in your handbook. So you see my sort of cheeky comment at the bottom of this slide, right? Lots of our clients come to us and say, oh, I haven't managed to do a handbook, or I have a payroll company and they gave me sort of their set template and I just used it. And, you know, we help them make sure their handbook is relevant and specific to New York law. And so oftentimes when a client has a handbook, right, they're really proud of themselves, right? Hey, I'm doing what I'm supposed to do. Well, this law came in and I'm not sure why, folks. And it insisted that this plan, and it's, you know, if you have it done right, it's probably 5 or 6 pages long. It has to be in your handbook. So a set aside, a separate policy where most of us might add to our handbooks with additions or appendices or exhibits, right? Here we've got to embody it right in the handbook. So it's something to look at. It's something to get done. If you don't have it in your handbook, but you do have it, listen, I'm not going to wrap your knuckles with a ruler about that. But the next time you do a wholesale revision of your handbook, go ahead and put it in. A couple other things to keep in mind. It needs to be distributed to all your employees. So everybody needs it, and your independent contractors. So if you work with independent contractors who do, you know, and these are the 1099 folks, right? Who do work for you and they come onto your setting, your office setting, your agency setting from time to time, you need to make sure it gets in their hands. My position would be out of an abundance of caution. Even your independent contractors who don't come on site, email it to them, make sure they have it. There is a requirement in the law that you be available to answer questions. And of course, that you follow what your plan says, right? That you do what's required. Here's where I'm going to say to those of you who are in our local government or a regional government, there is a corollary to the HERO Act. It's called the Emergency Preparedness Act. It is essentially the same as the HERO Act. And because I have such a fondness for charter schools, and I know that Sarah and the team at Lumsden do a lot of work for charter schools, please understand, charters, you folks know that you are a public school, right? Despite what might be viewed in, you know, sort of common parlance or the media, you know that you are a publicly funded school, but for a lot of purposes, you do not need to follow public school law. That is true here. So for charter schools, you are considered a private entity required to follow the HERO Act, not the Emergency Preparedness Act. So for my charter school friends on the webinar, make sure you've got your HERO Act policy and plan in place. You've distributed it to all of your personnel, your teachers, your admin staff, all of the folks who are in your constituencies, and that you follow it closely. So now we're going to get to our first poll, and we have it on your screen. Which New York governor triggered the HERO Act? Your choices are Andrew Cuomo, Kathy Hochul, Mario Cuomo, or none of the above. Let us know what you think.
Thanks. Sorry, everyone. Someone came into the office to get me something. Okay, I'm gonna close it out. And Lisa, would you like the results shared?
Oh, sure. What the heck? So looks like the vast majority of us thought Andrew Cuomo triggered the HERO Act. And while I can understand why you would have come to that answer, Andrew Cuomo was the governor when the statute was enacted. It was actually Governor Hochul who triggered the act this Labor Day weekend while I was grilling my hamburgers out in the backyard. So let's talk a little bit more about the HERO Act and why should you care, right? It's a question I get from clients, and it's a legitimate question, right? There are so many laws. New York doesn't make it easy for employers to do business, right? And again, whatever our views are of the government in its current complexion, we know there are these laws out there, and I'm particularly sensitive to issues around COVID because our state government has really enabled employees and others to articulate, to advocate for themselves. Many of us would say that that's a good thing because safety, and particularly public safety in the midst of a pandemic, is quite important. But I just took this sort of screenshot from the Department of Labor's website. And when you get the slide deck, you can read this over, but essentially what New York State is facilitating for employees is the ability to simply go online with, a couple of clicks on their smartphone and issue on this form goes on a little longer, issue a complaint about your entity. And it could be on a number of different issues, all relating to COVID, but it includes, right, both the HERO Act and the government corollary, the Emergency Preparedness Act. And while I haven't had any clients contacted by New York State because they're all super compliant, I imagine that where these complaints go, likely will be some follow-up by the state, particularly if there are more than one complaint for any particular entity. I'm just a bevy of good news this morning. So sometimes we have laws that don't have real obvious consequences. And while as an attorney, somebody licensed by the state and an officer of the court, I will always counsel clients to comply with the law. Sometimes there are laws that don't have particular consequences to them. And I can understand, though I don't agree with, that notion of, gosh, why should I put myself to this trouble? Why should my organization spend dollars on legal? Why should we have to focus on certain laws if there's really no consequence to us? Well, the HERO Act is a place where there are some pretty toothy consequences, I would call them. As you can see, there are some fines and penalties that the Department of Labor will slap on an organization that has failed to, one, have this plan in place, and two, when triggered, fails to execute on the plan. And we're still, this law, for one of the very first times, right in the history of New York State, permits employees to sue their employers. So those of you on the webinar who are HR professionals, right, you know, generally speaking, that when somebody is currently employed and they are injured or claim an injury on the job, workers' compensation satisfies that injury, right? You fill out all those workers' compensation forms, C2s and C3s. Reports are given. An insurance carrier, typically, unless you're self-insured, handles it, or a third-party administrator. And the employer, the company the person works for, is not sued. That's called the workers' compensation bar, right? The state says you have to buy workers' compensation insurance, and in exchange for having to pay those premiums, you get a shield, and you as the employer will not be sued. This law, for the first time, says an employee can sue her employer. And you see what the employee has to allege: that the employer either didn't have a plan or violated the plan, and it created a substantial probability that harm can come, or did come, or could result from that failure. And as we all know, any of us who have lived, you know, more than a few decades as adults, folks can sue for almost any reason or no reason at all. This statute gives employees the right to sue their current employers, which is a real departure from the workers' comp bar. So I want you to keep that in mind as a reason to take the HERO Act seriously. It's important to give this consideration, and it's important to not ignore it. And so our takeaways, right, about the HERO Act: create your plan, your prevention plan, have it. And right now it's triggered, so we got to be living it, right? We have to implement and execute it. We have to distribute it. The law suggests that there should be an opportunity for questions to be posed by employees and answers to be given by the employers in many situations. And this is one that's included. That sort of open communication, the availability for somebody who's employed by your organization to ask questions. Oftentimes, you know, and it might be perhaps a lot, and sometimes we have the gadfly employee, but having that open sort of line of communications often resolves issues before they get magnified, and you know, and you need to call in somebody like me to help you. And that's what I mean also about being visible, right? So what I mean by being visible is when this plan is triggered, as it is right now and has been for the past 3 months, be visible in the precautions you're taking in accordance with your plan, right? And so if you've taped out areas in your reception or in your conference room to ensure social distancing, or you do wiping down, disinfecting of high touch areas. I'll tell you, at my law firm, twice a day, I have an admin who goes around and wipes down doorknobs and high touch counters. And we have those, you know, not a commercial or anything, but we have that Clorox wipe container really visible. So our folks know, number one, if they need it, we want them to have it. But two, we're taking this seriously. And I know that that can be a very challenging situation the larger you are as an organization, but it's very important because of these reasons I talked about, right? So that's the HERO Act. And it exists right now. It's implemented and triggered right now. Take it seriously. By default, go to the Department of Labor website, get one of the template plans. They have them for different industries, which is kind of useful. And then modify it to your needs, or follow it to the letter so that you know that the state if it were to come in, if it were to field a complaint by someone, would have the evidence that you are doing what the law says you should be doing. So if you want to be super perfect and super documented, you have the option of, just like if you go into the restroom right at Wegmans or Target and you see that sheet of paper on the wall that says, you know, this area was cleaned at this time. Well, that's all lovely, and we like to think that the restrooms we're using are cleaned. That is a liability management tool, so that if somebody falls or is injured, the organization, Target, Wegmans, whoever it is, the public space, has evidence that someone was in there ensuring that there weren't dangerous conditions pretty frequently, at least a couple times a day. You could do the same thing if you choose to. Just keep a spreadsheet and have whoever is doing your high touch area disinfecting, just sort of log in. You can do it electronically, you can do it on paper. Another thing a lot of businesses are doing are the every morning, right as you get to work, questionnaires. You can do that online. You don't have to do it on paper. And then you have this history of showing your compliance. Do you absolutely have to do that? No. But if you want to be careful, it's a good idea. Kathy, thanks for your question. Is there an expiration date for the current HERO Act, the triggering of the HERO Act? So the act itself has no expiration date. It is here to stay. This current trigger, there is no expiration to it either. So we have to figure that it's going to be ongoing for quite a while. We don't know how long. And we simply have to abide its existence for right now. I wish I had, you know, a clear line of delineation, but I don't. So we'll move on to New York paid sick leave. We talked about this last December. It was brand spanking new. We had started accruing time, 30 hours of work for 1 hour of sick leave in the end of September of last year, but it went into effect January 1. So generally speaking, right, and I'm not going to read my slides, New York paid sick leave has nothing to do with COVID, but can be used for COVID. Is nothing to do. It is here to stay. It is a law that is very employee friendly and gives employees 40 hours of sick leave a year. You can sometimes 56, you'll see that on the slide. If you have 100 or more employees, it's 56 hours. So that's either 5 or 7 days of leave a year. Depending on the size of the business, it's either unpaid. So 4 or fewer employees and less than $1 million in revenue, that's unpaid leave, but still those hours. After that, it's paid leave. So at the person's regular compensation, you can choose to either accrue it, as I said earlier, for every 30 hours an employee works, they get 1 hour of sick leave. And so it slowly builds up through the year, or you can front load it. So at the very beginning of the year, you give your folks 40 hours. There's pros and cons to both of these ways of doing it. A lot of record keeping with the accrual, but lots of payroll companies have figured out how to help you with this. And there's, you know, issues with front loading because somebody can take their 5 days of paid sick leave at the end of January and then give their notice the next week, right? So, so there are issues both ways. I want you to remember the safety component, and that is we call it sick leave, but there's also parts of it that give people time off for safety related reasons, mostly relating to domestic violence type issues, human trafficking type issues, either for themselves or those they love. And so we need to broaden our viewpoints about what is allowable for this leave. There's this 3 business day rule, which means if somebody comes to you, like right now, a couple weeks ago, I had one of my admins come to me and say, how much sick leave do I have left? You have to, within 3 business days, be able to tell them how many hours they've taken, when they've taken it, and how much they have left for the year. So you have to have some good record keeping for that. It's protected leave, meaning you can't retaliate against someone for taking it. And as you folks might remember from last year, those of you who were with us, There is no particular advance notice required for this leave. And in fact, employers are essentially prohibited from demanding advance notice. That makes it very, very difficult to manage. So ultimately, sorry, I went a little bit too far. Ultimately, this leave, if somebody doesn't use it, it rolls over, but it does not necessarily have to have any cash value, but you need to have in writing in a handbook or your policy that sick leave has no cash value. So when someone leaves, and I know, collective bargaining agreements change these rules. I'm not talking about a CBA situation. I'm talking about a non-union employer can take the position that its employees, even if they've accrued and have rolled over more hours, may only take what the law says is required to give them per year. So in a less than 100 employee workplace, that's 40 hours. Over, it's 56 hours. So they might accrue a bunch of time because they're not getting sick and they're actually good employees who come to work and have a good work ethic. You can also say in your policy that when they retire or when they depart, they're not entitled to the cash value of that, but you have to do it in writing. So be advised that that's really important because you don't want all this leave, right? Or maybe you do, but be aware that if you don't limit there being a cash value to paid sick leave, then your employee, when she leaves, can take the position she's entitled to a cash payout.
Lisa, there's a question.
I'm seeing that question. So an employer with 35 full-time employees and 70 or 80 seasonal employees, that employer is considered a large employer with 100 plus employees. So, so it would be lovely if you could say, let me just count it in January when we don't have a big payroll. But the answer is, as soon as you go over that 100 employee limit, you're there. And so, so I'm afraid that you're stuck being considered a large employee, even if you have seasonal employees. And so now we have our next polling question so that we can get you education credits. An apple a day. 1, keeps the doctor away. 2, is good fiber for your bowels. 3, I don't know, ask William Tell.
We'll give this another minute, everyone.
Oh, goodness. We don't have to give this one a minute, Maria.
I want to make sure everyone gets their CPE credits. So.
That's right. That's right. If you've gone to grab your cup of coffee, rush back and answer the poll, please.
Yeah. Okay, I'm going to end it now and we'll share the results real quick.
Okay, we keep the doctor away. Good job, everybody. Glad to see your engagement. So the next law we're going to talk about, and this one is COVID specific. So this is the quarantine law. This was put in place right at the very beginning of the pandemic, last spring of 2020. This is more leave. It is more paid leave. How much somebody gets and what the composition of their leave benefits is highly dependent on the size of the employer. So PFL is the abbreviation for New York's paid family leave. DBL is the abbreviation for disability benefits. And PSL is what we just talked about. That's paid sick leave. So think about it as a bunch of buckets, right? Paid sick leave, as I've just talked to you about, is something you as an employer must fund. It comes out of your bottom line, right? On the other hand, paid family leave, which was new a few years ago, and we all got sort of antsy about that, but we figured it out, and disability are benefits for which you pay an insurance premium to an insurance company. And assuming you're not self-insured, they make those determinations. So that's a beautiful, beautiful thing. So if somebody is sick and has an order of quarantine, which everybody gets from their physician now, if they have symptoms or have to go for a COVID test, if they're out of work and they can't work from home, they would be entitled to a combination, depending on size of your organization, of paid family leave, which is 67% of their compensation and disability. If you're a little bit larger, you start with paid sick leave, which is typically those 40 hours, or if you're 11.99, it's 40 hours. Then they go on to paid family leave and disability if it goes longer, right? And if you're 100 plus employees, you must, here's another, out of your own pocket, you must fund 14 days paid COVID sick leave. So large employers kind of getting whipsawed no matter which way they turn. All of this is job protected leave, meaning, again, you cannot retaliate, you can't discipline somebody for taking this sort of leave. What does that mean? Sometimes it means people will take advantage of it. And I'm sorry to say that, but that's the reality. New York COVID sick leave, here's a great question. Does that include any time for vaccine reactions? The answer to that is no, but hang tight. We'll talk about vaccine time off in just a second. So no, New York quarantine leave is only if somebody is subject to an order of quarantine, meaning they've tested positive, somebody in their family has tested positive, or they're pending a test and their doctor has said, you must quarantine, right? That happens sometimes when somebody very close to you and your family, like you're a parent, and your kid comes home with COVID. We're seeing a lot of that this fall because kiddos until very recently couldn't be vaccinated, right? And so even vaccinated parents were getting these so-called breakthrough cases or starting to have symptoms, and they wanted to be careful. Bottom line, folks, right? We do not want anyone coming to work who might have COVID, right? It's a worst case scenario. So that's the COVID quarantine leave. New York paid family leave. We talked about that a moment ago. Paid family leave historically, when it was enacted, was not for the employee's own illness. It was only if, right, somebody in your family was ill. It was kind of the functional equivalent of the Federal Family Medical Leave Act statute, which only applies to larger 50 or more employee companies and organizations. New York paid family leave was historically not for the employee's own illness or injury, but it now includes COVID, but this is the one you have insurance for. So at least, you know, premiums aside, it's not coming out of your pocket. I wanted this slide because, as I said a moment ago, right, we are hearing so many situations where someone's kiddo is coming home from school or coming from travel hockey or travel soccer or whatever, and unfortunately becoming ill. Parents and guardians have the right to take time off pursuant to these laws to care for their children. Here, COVID vaccination leave. So here is the other law, right? We've had a lot of laws enacted in the aftermath of this pandemic. COVID vaccine leave is this particular section of the labor law of New York State again. And an employee is entitled to up to 4 hours of paid time off to get the vaccine and or for the consequences, right? I feel punky, I have a headache, I have body aches. It includes, as of just like a week ago, the Department of Labor informed us that this does apply to boosters. So if your employees are going for the Pfizer series, right? And it's 1, 2, and a booster, Moderna, 1, 2, and a booster. They get, up to 3 4-hour paid periods of time to get those vaccines. And you must pay them, and you can't retaliate or discipline them for it. I know it's frustrating because it would be really easy to schedule your vaccine at 6:45 at CVS, right? That's after many business hours. But employees have the right under New York law to get their vaccine during the day or to take 4 hours per vaccine because the law allows them to do it. This law does expire at the end of next year. I don't want to take any bets on whether it will be extended. My hope is that COVID is controlled by then and it will just naturally be put to bed. We're going to take another question. And this is the Americans with Disabilities Act. An ADA accommodation must include working from home, a lumbar support pillow, a comfort animal at my feet, all of the above, or none of the above. And then we have a bonus question. Are you attending this webinar to earn CPE credits? Please complete your poll now.
Thanks, everyone. Yes, please remember this is a part 2 question sneaking in the CPE credit question there. And this is the third poll. I apologize, they were inverted in the poll here. We're at about 80, almost 90% participated, so we'll just give it a few more seconds, Lisa.
Okay.
All right, I'm going to end the poll and we will share the results.
Okay, great. So we're going to talk about ADA in just a minute. So we will leave that to this slide. So I wanted to talk about the Americans with Disabilities Act. This is a federal law. It's not a New York State law, although there's some disability discrimination issues we'll talk about in a sec. The very first case has been filed by the EEOC, that's the Equal Employment Opportunity Commission, a federal agency, against an employer for failing to provide a COVID-related accommodation. This was an employee down in Georgia who wanted to work from home because she has pulmonary issues, and her physician wrote her out of work and said she should be able to work at home because her workplace involved her being very close to others. There was no way around that. And so her employer said no, even though they had allowed her to work from home during certain periods of the lockdown. They said, no, we've reached our limit. You got to come back to work. And she filed a complaint with the EEOC. And unfortunately, the EEOC has now filed a lawsuit. And so what does that tell us? We don't know what's going to happen there. But we know as employers, there are certain best practices. And because COVID makes it so sort of emphatic in front of us that folks have, many of them, learned to work from home, now want to work from home, right? Whether we read it in human resources journals and Business First, in the Buffalo News, everybody wants to work from home. And so as an employer, you may find that that is really advantageous to you, or you may find that it's a detriment for one reason or another, legitimate reasons to your business. But if you have someone with a disability who wishes to have a work from home or any other accommodation, lumbar pillow included, you should consider each request on a case-by-case basis. You cannot have a blanket. Anybody with a limp is not, allowed to take extra time to walk to the restroom. You can't have a blanket rule like that. You have to take everyone on a case-by-case basis. You should keep good records. You can require somebody to request in writing the accommodation, and you can, under the law, require physician backup, justification, certification to this. And what the law says is, can someone do the essential duties of their job with accommodation, as long as it is not an unreasonable burden on the employer? Well, what does that phrase, unreasonable burden, mean? Historically, it's meant, does it cost too much money, or is it so woefully disruptive to the business to make it an unreasonable burden? Understand, with many organizations having allowed, even required their employees to work from home during lockdown, it's pretty difficult now to make the case that it is an unreasonable burden to the business to have somebody work from home if that's the accommodation they're requesting because of a disability, right? You can't just ask for it because like you like to work in your jammies. You have to have a disability and a physician justification for that, right? So there are some limitations here that help us to manage our workforce, but it's really important to look at each one of these on a case-by-case basis, to keep these records, to do performance reviews, and to follow through, right? If somebody is granted, let's say, an accommodation to work from home, but they never show up to the Zoom team meeting every Monday morning at 9 a.m., well, that's something, again, you should be reviewing them on contemporaneously, right? When that happens one time, hey, Marge, you needed to be at that meeting. It's required even though you're working from home. And it happens a second time, maybe you escalate that to a written warning in a file. You do these things not because you're retaliating on the basis of the disability or the accommodation, but because they're supposed to be able to do the essential duties of their job, even with that accommodation. And if they can't, i.e. they don't show up for meetings, that's a legitimate reason. Again, I'm talking about a non-unionized workplace. It's a legitimate reason for discipline and potentially termination. These are hard conversations to have. You'll see my cheeky comment, don't be a weenie. Don't avoid having the difficult conversations. HR professionals are used to having difficult conversations. I know I don't need to say that to you, but for those of you who are executive directors, who are superintendents, who are heads of schools, these are really hard conversations to have sometimes, and you want to be effective. So get yourself some good guidance from folks who have some expertise in the area. And I'm going to move on quickly because we're close to running out of time to disability discrimination. We're seeing some of these claims being made on the basis of long haul COVID. That's a real thing. And pre-existing conditions that make COVID consequences even more dramatic. New York, and here I'm going to focus again back to New York law. Our New York discrimination statute says equality of opportunity is a civil right. So discrimination can be on the basis of disability, that's what I started with, or can be on the basis of any other protected class. We know the common ones folks talk about: gender, right? Women versus men, age, the bright line is 40 years old, race. There are some other ones under New York law: pregnancy, perceived sexual orientation, gender identity, domestic violence victim, and folks who believe they have claims for employment discrimination and some other discrimination that's not relevant here, have a year to bring their claim at the Division of Human Rights. That's a New York State employment and labor related agency that will take up their cause for them. I'm going to take just a moment to talk about sexual harassment because it's still around. Unfortunately, it shouldn't be, but it is. And New York law addressed it a couple of years ago by passing a law that required mandatory sexual harassment prevention training in every workplace. 1 employee, 1,000 employees, everybody needs to be trained on sexual harassment prevention annually. This is one of those laws that if somebody then makes a claim for sexual harassment, having not trained will be evidence of the employer's failure to have in place the appropriate protections for employees. Here, there's a 3-year statute of limitations, meaning somebody who believes they've been harassed can wait 3 years to bring their claim. The test for sexual harassment now is a very, very low bar, folks. I think I mentioned this last year, but it bears repeating. Used to be, and under the federal standard, it's sexual harassment is only sexual harassment if it's severe and pervasive. It happens a lot and it's really bad. Now in New York, it's the lowest bar ever, as long as it's not what's called a petty slight. The claimant will be able to bring a claim and could successfully extract money damages from the employer. What I say here, it's not just grabbing. So touching obviously is sexual harassment in the workplace, but it's all sorts of other things. It's stupid pictures from somebody's Instagram feed. It's telling off color jokes. it's innuendo. There are all sorts of things that qualify, unfortunately, as sexual harassment. And as our workforce, some of it ages, folks who've been around, right, in the workforce since the 70s, 60s, maybe 70s, 80s might have a different view on what's appropriate and inappropriate. So this training is even more important for that, to educate folks about what they should and shouldn't be doing. We do offer online training. So that's a sort of a plug for our webinar-based training if it's difficult to get all your employees together or not safe given a pandemic. So here's our last poll. A hostile work environment means the boss yells a lot, male coworkers grope female coworkers, employees never get a raise. None of the above or all of the above.
We do have a couple questions, and those who asked them and who see the questions, we will get to them before we end.
Yep, I'll answer them while we're doing the poll. So if the employer mandates quarantine, not the doctor or the Department of Health, is that covered under the New York State quarantine leave? So New York State quarantine leave requires an order of quarantine. However, if the employer feels it's most protective of the workforce to say to an employee, you should stay home because you've been exposed or you've shared with me that you've been exposed, ultimately, while it's not covered by the statute, it should be paid leave. Could I argue the other way? I could, but I think I lose 99 out of 100 times because it's the employer that's mandating it. So although that's not covered by that law, it should be paid leave. And then does the employee have to provide an actual order of quarantine to receive the quarantine leave pay? If they only provide a positive test result, does it still apply? So generally speaking, the answer is a positive test. They're entitled to the leave. And there are, again, corollary laws that deal with public employers that I believe, and here's where I don't have an absolute answer. So if you want to circle back to me, you'll see my contact information. I'd be happy to make sure of the answer. I believe there is a corollary law for public employees on this point, but I'd like to double check that for you. So poll 4, we got it. We got answers. So hostile work environment. I like talking about it, and I'm just going to talk about it for a second because we're just about done. We think about hostile as normal people think about hostile, right? We yell, we're nasty, we're mean, we pick on people. That is not what a hostile work environment is. Hostile work environment is a term of art lawyers and judges use to describe a workplace that is pervasive with sexual innuendo. It is not a workplace where the boss yells a lot or is a son of a gun. And so if, and I get a lot of calls from people who say, my boss is really mean to me, I want to sue, right? I always talk about it, and you'll all forgive me, as the no asshole rule. There's a great book with that title. Professor Robert Sutton wrote it. I have it on my bookshelf. It's a great read. In New York and under federal law, there isn't a lawsuit for the boss being an a-hole, but for good practices, and I think my good friend Kim Wallace is going to talk a little bit more around these issues in just a moment. Just because you can't bring a lawsuit, your employee can't sue you, doesn't mean it's right or appropriate. And so there are always places to improve the workplace, the morale of the workplace. I know it's a challenging time, folks. Our clients are feeling it. We're feeling it. Businesses are feeling it, and organizations are feeling the pinch of the labor crisis because of COVID and because of where we are in our, I guess, in our country's history. But there's always room to improve workplace dynamics and communication. That brings me to the end of this presentation. I want to thank you all for your kind attention. Great questions, folks. And if anybody has further questions, don't hesitate to ping me. I think you've got my cell number and my email address.
Thanks very much, Lisa. I think you brought some insight definitely into that topic, maybe stress people out about some things they need to be doing that they aren't. As Lisa mentioned, Kim Wallace will be presenting next on eliminating implicit bias and promoting emotional intelligence. The link to her presentation is in the chat. You should also have it in your email. Lisa's presentation will be available on our website later. Her contact information, as she said, is in the chat, but it is also available on our website and the link to the conference. And with that, I think I'll turn it back to Maria. Thanks, Lisa.
Yes, thanks, Lisa and Sarah. Of course, Lisa, you're becoming a regular and we appreciate that. So thank you. We are preparing the next session. So everyone who's still on, just give us another minute or two and we should open that right at 10 o'clock. So we hope to see you on the next session and at 11 and again tomorrow. So thanks everyone and we'll see you soon. Thank you.